For today's story, we look at one of the big ones this term, dealing with race-based preferences at colleges. Many colleges have a race-based preference and give points or other advantage to people of particular race or racial backgrounds. Of course, by necessity, giving someone an advantage necessarily puts someone else at a disadvantage, because to add points to someone is exactly the same mathematically as subtracting those points from someone else. You can't advantage someone without disadvantaging someone. So, should we advantage certain races on the basis of race? Well, if we do that, we have race based preferences and we're discriminating also on the basis of race. So, that's a problem. But this has been legal up until now, and now it's being challenged in this case. Students for Fair Admission versus Harvard versus UNC. One, of course, is a private college. One, of course, is a state college. So this court could, of course, split the difference there if it wanted to, because only the state is applicable to the Constitution. But there is a statute in place, the Civil Rights Act, that says there shouldn't be discrimination on the basis of race. So if we decide this on purely constitutional grounds, we might split the difference. If we decide this on statutory grounds, we might not. Let's go ahead and see what's going on with this. Harvard College, which is the oldest college in the United States, and the University of North Carolina are two of the oldest institutions of higher learning in the United States. Well, Harvard College is literally the oldest, I believe. And so, yeah, that's part of their tradition. Every year, tens of thousands of students apply to each school. Many fewer are admitted. Both Harvard and UNC employ a highly selective admission process to make their decisions. Admissions to each school can depend on student grades, recommendation letters, or extracurricular involvement. It can also depend on race. The question presented is whether the admission systems used by Harvard College and the University of North Carolina are lawful under the Equal Protection Clause of the 14th Amendment. At Harvard, each application for admission is initially screened by a first reader who assigns a numerical score in each of 6 categories: academic, extracurricular, athletic, school support, personal, and overall. For the overall category, a composite of 5 other ratings, a first reader can and does consider applicants' race. Harvard's administration subcommittees then review all applications from a particular geographic area. These regional subcommittees make recommendations to the full admissions committee and then take an applicant's race into account. When the 40-member full admission committee begins its deliberations, it discusses the relative breakdown of applicants by race. The goal of the process, according to Harvard's director of admission, is ensuring that there's no dramatic drop-off in minority applications from the prior class. An applicant receiving a majority of the full committee's votes is tentatively accepted for admission. At the end of the process, the racial composition of the tentative applicant pool is disclosed to the committee. The last stage of applicants' process, called the LOP, winnows the list of tentatively admitted students to arrive at the final class. Applicants that Harvard considers cutting at this stage are placed on the LOP list, which contains only 4 pieces of information: legacy status, recruited athlete status, financial age eligibility, and race. In Harvard's admission process, race is a determinative tip for a significant percentage of all admitted African American and Hispanic applicants. Okay, so what we've got here from the idea of Harvard is we're considering race basically every step of the way. We consider it as part of their initial rating. So there is a guy who does an initial rating for each applicant who, as part of that, considers race. And then their recommendations get bumped up to a regional committee, which considers race. And then their recommendations get bumped up to a 40-member final determining committee, which then determines whether or not to admit people by a majority vote. They wind up with more people than they can support. And then they have to figure out how to winnow down the people that receive majority support to the actual admission list. And at that point, they also consider race explicitly. So at every step of the way, race provides an advantage, a discriminatory factor. Okay. UNC has a similar admissions process. Every application is reviewed first by an admission officer reader who assigns a numerical rating to each of several categories. Readers are required to consider the applicant's race as a factor in review. Readers then make a written recommendation on each assigned application, and they may provide an applicant a substantial plus depending on an applicant's race. At this stage, most recommendations are provisionally final. A committee of experienced staff members then reviews a school group review of each individual decision made by a reader and either approves or rejects the recommendation. In making those decisions, the committee may consider race. So UNC does a simpler process. They have a guy who looks at it and makes a determination, yes or no. That guy's decision is presumptively correct. And in reviewing it, in terms of its correctness, the admissions committee also considers race. All right, petitioner. For Students for Fair Admission is a nonprofit organization whose stated purpose is to defend human and civil rights secured by law, including the right of individuals to equal protection under law. The SFFA filed separate lawsuits against Harvard and UNC, arguing the race-based admissions violate, respectively, Title VI of the Civil Rights Act, because that would apply to a private school, and the Equal Protection Clause of the 14th Amendment, which would apply to the government school. After separate bench trials, both admissions programs were found to be permissible under the relative precedent, which would be correct for the lower courts. That would be the correct decision given the precedent, because only the Supreme Court can change the precedent, so the lower courts were kind of bounded here. In the Harvard case, the First Circuit affirmed, and this court grants certiorari. In the UNC case, this court grants certiorari before judgment. So they yanked it out of order, right? Having seen that the First Circuit case was asked for review, they decided to also take along UNC for the ride. So it had been appealed to the Court of Appeals, but they decided to yank it out of order, which of course the Supreme Court can do because it's a higher court of review. Okay, with that background, what is the relative law? Held, Harvard and UNC's admissions programs violate Equal Protection Clause of the 14th Amendment. Okay, that's kind of interesting. We want to say that Harvard is violating the Equal Protection Clause of the 14th Amendment. All right, that's interesting because Harvard is a private institution. So the immediate thought I have is, how can Harvard violate the Equal Protection Clause? Is it because they accept governmental money and that means that they're bound by the Equal Protection Clause? You know, what is their tie to the Equal Protection Clause? If they said that Harvard is bound by the statute, then I would understand. But they say that Harvard is bound by the Constitution. Why? Let's read more. Because the Students for Fair Admission complies with standing requirement for organizational plaintiffs, the SFFA's obligation under Article 3 are satisfied and the court has jurisdiction. Yeah, we don't really have time to really delve into the depths of when an organization has standing to bring claims on behalf of its members. The court's going to talk about it a little bit now, but it's a little bit more complicated than the court's about to let on. So we don't really have time to get into it, but they say that, yes, they're standing. The court rejects UNC's argument that the organization lacks standing because it's not a genuine membership organization. An organizational plaintiff can satisfy standing in one of two ways, one of which is to assert standing solely as a representative of its members, an approach known as representative or organizational standing. To invoke it, an organization must satisfy a three-part test. Respondents do not suggest that the organization fails the test for organizational standing. They argue instead the organization cannot invoke organizational standing at all because it's not a genuine membership organization at the time it filed suit. So yes, they meet the tests, but they're really a fraud, is the idea. They superficially meet the test you've laid out, but it's not really a membership organization. They're just pretending to be one. Okie dokie. The respondents maintain that under the relevant law, a group qualifies as a genuine membership organization only if it's controlled and funded by its members. In a relevant case, this court determined that a state agency with no traditional members could still qualify as a genuine membership organization in substance because the agency represented the interests of individuals and otherwise satisfied the three-part test for organizational standing. So yes, there might be a state-level agency that represents a group of people. For example, the thing that would come most notably to mind might be in relation to alcoholic beverages, because obviously that's a regulated trade. And so those organizations, even if they're state created, might represent its members. and might have an interest in its members, who might even be compelled to be members, but still might have an interest to raise the interest of its own members. So the fact that it's not controlled by the members because it's a state agency is not a problem, apparently. The indicia of membership analysis in the prior case law has no applicability here. As the court found below, the SFFA is indisputably a voluntary membership organization with identifiable members who support its mission and whom they represent in good faith. They're thus entitled to organizational standing. So first of all, membership control is not necessarily required. Second of all, it's not relevant here because this really is a membership organization, not a fraud. So fine. And also, that would be presumably a question of fact. Yeah, whether SFFA is really a membership organization or whether it's a fraud is underlyingly a question of fact. So it's not surprising that the Supreme Court, of course, defers to the lower court on that because it's a factual-based question. So fine. Proposed by Congress and ratified by the states in the wake of the Civil War, the 14th Amendment provides that no state shall deny any person the equal protection of the law. Proponents of the Equal Protection Clause describe its foundational principle as not permitting any distinctions of law based on race or color. Any law which operates on one man, they maintained, should operate equally on all. Accordingly, as this court's early decisions interpreting the Equal Protection Clause explain, the 14th Amendment guaranteed that the law in the states shall be the same for black as white, that all persons, whether colored or white, shall stand equal before the laws of the states. Despite the early recognition of the broad sweep of the Equal Protection Clause, this court, along with the country, quickly failed to live up to the clause's core commitments. For almost a century after the Civil War, state-mandated segregation was in many parts of the nation a regrettable norm. This court played its own role in that ignoble history, allowing Plessy versus Ferguson, the separate but equal regime that would come to deface much of America. So the Supreme Court throwing a little shade on itself, and well-earned shade at that, because, yeah, the Supreme Court, along with states, along with a lot of other things, did not really give full faith to the Equal Protection Clause for quite some time when it came to state-based action. After Plessy, American courts labored with the doctrine of separate but equal for a half century. Yeah, that mistake lasted a while, guys. Some cases in this period attempted to curtail the perniciousness of the doctrine by emphasizing it required states to provide black students educational opportunities equal to, if even formally separate from, those enjoyed by white students. So yeah, perhaps somewhat unsurprisingly, after Plessy, people didn't really like it so much, and so they tried to whittle down at it without overruling it explicitly, because the Supreme Court doesn't like to really admit it makes mistakes. So they try to create these exceptions and create these carve-outs, and then you eventually wind up at a place where the underlying doctrine is so carved out and so broken that there's nothing left. You basically carved out everything. And yeah, that's kind of what happens. So eventually you have to admit that you made a mistake because you've carved out everything, so there's nothing left. Yeah. But the inherent folly of that approach of trying to derive equality from inequality soon became apparent, as this court subsequently recognized even racial distinctions that were argued to have no palpable effect worked to subordinate affected students. By 1950, the inevitable truth of the 14th Amendment had thus begun to reemerge. Separate cannot be equal. Yeah, there were definitely some mistakes made along the way when it came to the interpretation of, racism is bad. And it's how about some racism? How about separate but equal? Is that okay, racism? Yeah. The culmination of this approach finally came in Brown versus Board. There, the court overturned the separate but equal regime established in Plessy and began on the path of invalidating all de jure, which is to say, by law, racial discrimination by the states and federal government. This court reached the conclusion in Brown that was unmistakably clear. The right to public education must be available to all on equal terms. The court reiterated the rule just 1 year later, holding that full compliance with Brown required schools to admit students on a racially non-discriminatory basis. Yeah, we figured that out a long time ago in Brown, and apparently still having the problem. Some schools still have apparently not gotten the memo. In the years that followed, Brown's fundamental principle that racial discrimination in public education is unconstitutional reach other areas of life. For example, state and local laws requiring segregation in busing, racial segregation in the enjoyment of public beaches and bathhouses, and anti-miscegenation laws, which is where you can't marry someone of a different race. These decisions, along others like them, reflect a core purpose of the Equal Protection Clause, doing away with all government-imposed discrimination on the basis of race. That does seem to be what the 14th Amendment says. I mean, it says equal protection of the law. And if the 14th Amendment wasn't enough clue, there's also the 13th and 15th Amendments, which also speak about race very explicitly. So, probably should treat the races the same. If we look at the Constitution, that's kind of what they had in mind. Okay, eliminating racial discrimination means eliminating all of it. Sounds good to me. Accordingly, this court has held equal protection clause applies without regard to any difference of race, color, or of nationality. It is universal in its application. For the guarantee of equal protection cannot mean one thing when applied to one individual and something else when applied to another person of color. Yeah, because if equal protection meant something different based on color, how equal is it? Yeah. Any exceptions to the Equal Protection Clause guarantee must survive a daunting two-step examination known as strict scrutiny. That's what it's supposed to do, yes, which asks first whether the racial classification is used to further a compelling governmental interest. The word compelling here is carrying a lot of weight, by the way, because when we think about the three major standards, and there are little substandards, depending on which case you're reading, but for the three major categories, there are three ways the government can act, right? It can act normally. It acts in sort of intermediate scrutiny or strict scrutiny. Intermediate scrutiny we typically do for example, sex-based discrimination. All right, so if we want to go through the relevant standards, we move from a legitimate governmental interest to an important governmental interest to a compelling governmental interest. So the word compelling here is doing a lot of heavy lifting. And what we mean by compelling is compelling, right? Not just legitimate, not just important, compelling, urgent, required. That kind of thing is what we're looking for. And second, whether the government's use is narrowly tailored. That is necessary. So is it basically the least you can possibly do? Because we think that this kind of discrimination is really, really bad. So in order for you to discriminate in this kind of way, your interest has to be really, 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 really important. And it also has to be as small as it can possibly be, right? You have to solve the problem and no more. No broad solutions. This has to be a very pinpoint, nuanced solution in order to deal with the problem so as to not to undermine the rule. So that's the only way we'll allow this. Admissions of race-based state action is rare for a reason. Distinctions between citizens solely because of their ancestry are by their very nature odorous to a free people whose institutions are founded on the doctrine of equality. Yeah, strict scrutiny is supposed to be really, really hard. Strict scrutiny has been called strict in theory and fatal in practice because you're not supposed to be able to make strict scrutiny. It's supposed to be really hard. So yeah, it basically should never work. And the exceptions are truly the exceptions. And only for the most compelling reasons and only in the most narrow cases. Right? So are you getting the idea? Yeah. The court first considered whether a university may race-based discrimination in Bakke in a deeply splintered decision that produced 6 different opinions, which is always such a joy for all of us working in Supreme Court land when the Supreme Court can't come up with a unanimous opinion and we start having to count to 5. Counting to 5 sometimes is really, really hard. So when the Supreme Court can't come up with 5 and we have to count to 5, it leads to nightmare fuel. So not surprisingly, Bakke led to nightmare fuel. Justice Powell's opinion for himself alone would eventually come to serve as the touchstone for the analysis of race-based policies, as we decided in a later opinion called Grutter. So when we figured out how to count to 5, we said that Justice Powell's opinion, even though he only wrote for himself, was the controlling opinion. Because that's sometimes how you count to 5. It's annoying. Anyways, after rejecting 3 of the university's 4 justifications as not being sufficiently compelling, Justice Powell turned to its last interest, asserted to be compelling, obtaining the educational benefits that flow from a racially diverse student body. Justice Powell found this interest to be constitutionally permissible, goal for an institution of higher education, which was entitled as a matter of academic freedom to make its own judgments as to the selection of a student body. But the university's freedom was not unlimited. Racial and ethnic distinctions of any sort are inherently suspect. Justice Powell explained an antipathy towards them was deeply rooted in our nation's constitutional and demographic history. Accordingly, a university could not employ a two-track quota system with a specified number of seats reserved for individuals from a preferred ethnicity group. Neither still could a university use race to foreclose an individual from all consideration. Race could only operate as a plus in a particular file, and even then had to be weighed in a manner flexible enough to consider all pertinent elements of diversity in light of particular applications of the applicant. So, yeah, you can't do any sort of quota. You can't do any sort of set number. You can only be a plus factor and only in combination with other factors. That's what Justice Powell kind of wrote. For years following Bakke, the lower court struggled to determine whether Justice Powell's decision was binding precedent. I'm not surprised because, again, counting to 5 can be really hard when you're talking about the Supreme Court. What is the controlling opinion? And you hope that one of them is the controlling opinion. And you don't even know then, because sometimes it's a combination of opinions and it's really, really annoying. So the lower courts, unsurprisingly, struggled with counting to 5 because counting to 5 is really, really hard. So when you have these split opinions, it's really, really annoying. Then in Grutter, the court for the first time endorsed Justice Powell's view that a student body diversity is compelling state interest. The Grutter majority analysis tracked Justice Powell's in many respects, including his insistence on how limits of the university may consider race in admissions. Those limits, Grutter explained, were intended to guard against two dangers that all race-based government action portends. The first is the risk that the use of race will devolve into illegitimate stereotyping, which implies there's such a thing as legitimate stereotyping, but I digress. Admission programs thus could not operate on a belief that minority students always, or even consistently, express some characteristic minority viewpoint on any issue. So yeah, it'd be kind of racist to assume that you admit a black person and they're going to have a black perspective, whatever that means, right? Which is one of the things that universities are doing, right? We're admitting black students because they have black perspectives. But that's kind of racist, isn't it? Yeah. To manage these concerns, Grutter imposed one final limit on race-based admissions. At some point, the court held they must end. Recognizing that enshrining a permanent justification for racial preferences would offend the Constitution, unambiguous guarantee of equal protection, the court expressed an expectation that in 25 years, the use of racial preferences will no longer be necessary to further the interest approved today. 20 years have since passed since Grutter, but with no end of race-based admissions in sight. But when the court has permitted race-based college admissions only within the confines of narrow restrictions, such admission programs must comply with strict scrutiny, may never use race as a stereotype or negative, and must, at some point, end. Respondents' admission system fail each of these criteria and therefore be invalidated under Equal Protection Clause of the 14th Amendment. Respondents fail to operate their race-based admissions program in a manner that's sufficiently measurable to permit judicial review under a rubric of strict scrutiny. First, the interest that respondents view as compelling cannot be subjected to meaningful judicial review. Those interests include training future leaders, acquiring new knowledge based on diverse outlooks, promoting a robust marketplace of ideas, and preparing engaged and productive citizens. While these are commendable goals, they are not sufficiently coherent for the purposes of strict scrutiny. It is unclear how courts are supposed to measure any of these goals, or if they could, to know when they've been reached so that racial preferences can end. The elusiveness of respondents' asserted goals is further illustrated by comparing them to recognized compelling interests. For example, courts can discern whether temporal racial segregation of inmates will prevent harm to those in prison, but the question of whether a particular mix of minority students produces engaged and productive citizens or effectively trains future leadership is standardless. Second, respondents' admission programs fail to articulate meaningful connection between the means they employ and the goals they pursue. To achieve the educational benefits of diversity, Respondents measure the racial composition of their classes using racial categories that are plainly overbroad, expressing, for example, no concern whether South Asian or East Asian students are adequately represented as Asian, arbitrary or undefined the use of the category Hispanic, or under-inclusive, no category at all for Middle Eastern students. The unclear connection between goals that respondents seek and the means they employ preclude the courts from meaningfully scrutinize respondents' application programs. The university's main response to these criticisms is trust us. They assert the universities are owed deference when you use race to benefit some applicants but not others. While this court has recognized a tradition of giving a degree of deference to a university's academic decisions, it is made clear that deference must exist within a constitutionally prescribed limit. Respondents have failed to present an exceedingly persuasive justification for separating students on the basis of race that is measurable and concrete enough to permit judicial review as the Equal Protection Clause requires. Respondents' race-based admission systems also fail to comply with the Equal Protection Clause's twin commands that race may never be used as a negative and may not operate as a stereotype. The First Circuit found that Harvard's consideration of race has resulted in fewer admission of Asian American students. Respondents assert that race is never a negative factor in their admissions, cannot withstand scrutiny. College admissions are a zero sum, and benefit provided to some applicants but not others necessarily advantages the former at the expense of the latter. Yeah, to add to someone is necessarily to subtract from someone else, right? It's zero sum because the college is only going to admit so many people. They're only going to admit so many people. And so among those people, to admit someone is to not admit somebody else, right? Their classes can only be so big. So to give someone else a plus is exactly the same thing as giving someone else a minus. It's mathematically the same. Giving someone an advantage is to give someone else a disadvantage. It's mathematically the same. So yeah, to give someone an advantage is at the expense of other people. Respondents' admissions programs are infirm for a second reason as well. They require stereotyping, the very thing Grutter forswore. When a university admits students on the basis of race, it engages in an offensive and demeaning assumption that students of particular race, because of their race, think alike. Such stereotyping is contrary to the core purpose of the Equal Protection Clause. Respondents' admission programs also lack a logical endpoint as Grutter required. Respondents suggest that the end of race-based admissions programs will occur once meaningful representation and diversity are achieved on college campuses. Such measures of success amount to little more than comparing the racial breakdown of the incoming class and comparing it to some other metric, such as the racial makeup of the previous incoming class or the population in general, to see whether some proportional goal has been reached. The problem with this approach is well established. Outright racial balancing is patently unconstitutional. Respondents' second proffered endpoint, when students receive the educational benefits of diversity, fares no better. As explained, it's unclear how a court is supposed to be able to determine if or when such goals will be adequately met. Third, respondents suggest the 25-year exception to Grutter means that race-based preferences must be allowed to continue until at least 2028. The court statement in Grutter, however, reflected only the court's expectation that race-based preferences would, by 2028, be unnecessary in the context of racial diversity on college campuses. Finally, respondents argue that the frequent reviews they conduct to determine whether racial preferences are still necessary obviates the need for the endpoint. But Grutter never suggested that periodic review can make an unconstitutional condition constitutional. Because Harvard and UNC's programs lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner, involve stereotyping, and lack meaningful endpoints, these admission programs cannot be reconciled with the guarantees of the Equal Protection Clause. I'm still wondering how Harvard is bound by the Equal Protection Clause. At the same time, nothing prohibits universities from considering an applicant's discussion of how race affected their applicant's life, so long as this discussion is concretely tied to a quality of character or unique ability that a particular applicant can contribute to the university. Many universities have far too long wrongly concluded the touchstone of an individual's identity is not challenge bested, skills built, or lessons learned, but the color of the skin. This nation's constitutional history does not tolerate the choice. Roberts delivers the opinion in which Thomas, Alito, Gorsuch, Kavanaugh, and Barrett join. Thomas concurs, Gorsuch concurs, Kavanaugh concurs. Sotomayor dissents in which Kagan and Jackson join. Jackson files a dissent in which Sotomayor and Kagan join. Jackson took no part in consideration of the case from UNC because I believe she heard that case. No, apologize. Jackson took no part in consideration of the case dealing with Harvard because she had some particular ties to Harvard, so she cast no vote on that. So this is 6-3 and 6-2, respectively. Thus, that brings us to the end of discussion for the moment of the Supreme Court case of Students for Fair Admissions versus Harvard versus UNC. And the takeaway, at least for the moment, is that race-based discrimination is banned, at least as it applies to non-military schools, because there's a footnote that says maybe the military schools, but we're not going to reach that decision today. But as to that, we'll see. As to these schools, however, not so much with the race-based administration. Race-based is wrong. And we'll see how that all progresses with all that, at least for a moment. That brings us to the end of discussion of this story.